Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today, we've got a couple things to read. I mentioned it on Twitter. It's in the description. You guys know. So, yesterday, was it yesterday? I think it was. I read a strange email that I got. And the person who sent me the email clearly was either watching live. I don't know if that's true, if they were watching live, but they did apparently watch because they sent me some more emails today, kind of follow-ups and stuff like that. So I think we're going to read those in just a little bit, kind of a primer maybe on the show. What is it? I don't know. We're gonna do that as the lead up, and then once we do that, the reading of these emails, and he sent me several. They're not all as long as the other one, but you know, I don't know, this guy's got some stuff to say, so I figured we'll indulge it a little bit. I don't know how long we're going to do it, but, you know, it's mildly interesting to me. So, it's always interesting to me, again, to see where different worldviews come from, where they go. And this one is a little bit different from mine. And then after that, going to read this case. And we'll start with the decision that the appeals court made. The decision, this is a TCPA case, and it was run by none other than Wick Phillips, attorney law firm for Monica Rial and Ronald Toye. Now, Lemongrass wasn't actually the lawyer on this one. No idea why. He's their TCPA expert. Maybe this case made them decide that they needed a TCPA expert, because, oh boy, it doesn't, spoiler alert, avert your ears if you don't want to hear it. It doesn't go well for Wick Phillips. They're the plaintiffs in this case. They are suing on behalf of their client. They are suing someone. It's how do I put this? Just remember that not only do Law Twitter love Wick Phillips and love to shit on Ty Beard, okay? And Beard Harris. They think that this lawsuit Vic brought was ridiculous, and that only an attorney as dumb as Ty Beard would bring a lawsuit that is ridiculous like Vic's. I want you to remember that Law Twitter, Lemons, all of these people think that Vic's case is bad, ridiculous, frivolous, and that Ty is making bad arguments. I want you to remember that when we review this case. It's going to be great. Great. So, I don't know, maybe Lemon was on the undercard fight prior to the appeals court. I don't know. I'll have to look into that maybe. But we may do a deeper dive into this case as well. I cannot take credit for finding this. I don't know. This was presented to me by Spectre. Spectre sent me this. I don't know if he looked it up. I don't know if he got it from somewhere else. I'm just saying I didn't go out and find this. This was sent to me. I didn't read every word of the decision today because, you know, excuse me, wanted to say some for the show. Didn't have a ton of time, but I read enough of the decision, skimming through some parts of it, and I read a lot of it, okay? I read probably 70%, but we'll read through the rest of it, or we'll read through the whole thing and take a look at those top quality arguments from the best law firm ever. Just remember that what every law school graduate would know about defamation, right? Every one of them. We'll do that. But first, real quick, let's address the elephant in the room, which is a joke. Trump has been impeached. He joins the illustrious list of only two other presidents to actually be impeached. Andrew Johnson and Bill Clinton. Trump has been impeached. So now, whatever charade of impeachment is going on will be conducted in the Senate. I've got some predictions. I don't know if they're going to be right because who knows what the Senate's going to do. How they're going to set. An impeached president just means that the House has voted to pass articles of impeachment. That's all it means. It doesn't mean that anybody's removed from office. All of that trial stuff comes later. That messy aspect of trial comes a little bit later. And when the Senate does it, what their timeline is, I don't know. It'll be presided over by Chief Justice John Roberts. And let's see. Oh, sorry. I got a text right there. That was good. Chief Justice John Roberts will preside over the trial, whatever that may be, but that happens in the Senate according to Senate rules. There's no guidance in the Constitution on it. Ultimately, it will come down to a vote. A 2/3 majority of the Senate, of the voting Senate, of a Senate quorum must... a 2/3 majority must vote to remove the president from office. Otherwise, the impeachment fails. There are two counts. There's the obstruction of Congress and the obstruction of justice. And this is history. This matters. I'll tell you the same thing I told my high school students when we were talking about impeachment and all of this stuff a couple weeks ago is whether or not you care, this defines how the interaction between the House, Senate, and President will be conducted going forward. There's so little precedent on impeachment that every one of these things is massively, massively important. And how they do it will guide how it's done the next time and the next time. Problem for the Democrats in the House and problem for the Democrats in the Senate is that the Supreme Court has agreed to hear an issue over Trump being subpoenaed. And they did that, but it seems like the earliest they're going to hear that is March of next year. So what the Democrats will really want is for the impeachment to be delayed past that because they, I guess, assume that they would be able to find something more to convince the people or the Senate or whatever about Trump's misdeeds, or they can use it as a nice cover. Who knows? I think the Republican Senate will want to get this done before that. We'll hear the impeachment prior to that decision being rendered by the Supreme Court, and and then everyone can complain, right? Everyone can complain about it because if they deal with it before that, the Republicans have cover. They have some cover because if something really is damning in the documents that he would turn over, the Republicans could say, well, we didn't have that info, impeach him again or whatever, if you dare. And the Democrats will be able to use the early action of the Republicans to carry on whining, saying they didn't get to conduct a thorough investigation and they were obstructed and all of these things, blah, 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 blah. And it's all just enough for both sides to bleat back and forth and carry that into the election. It's perfect because the outcome of the impeachment matters, but not as much as what's going on leading up to it, in my opinion. For what it's worth, I don't think Trump is leaving office prior to being elected out or finishing up a second term, whichever one of those there may be. And I think that every moment that this impeachment goes on gives him a greater chance of winning in 2020. I don't know if he's got enough to win in 2020. I know that both sides are desperately trying to energize their bases, and they think that this impeachment is the way to do it. Both of them do. And so maximizing the way to drive donations and to get voters to polls, that is, for both parties, seems to be the way that this would go if there were some evil mastermind behind it. Or if there were just, a socially stunted group of elites running it all. And by that, I mean Congress. So, I think that's what's going to happen. But anyway, expect an impeachment sort of 101, very high level video coming out in the next day or so. And this will be a high level constitutional look at impeachment. There may be some follow-up videos about this impeachment, about the previous two impeachments. I don't know. It's not a realm of expertise of mine, but I want to point out that it's not really like the historical impeachments. There can be people who are experts on those for sure. But impeachment in general, anyone claiming to be like an expert on impeachment, there's not much material to be an expert on. This is uncharted. It's uncharted and really unchartable territory. So the guidance is entirely in the Constitution, and outside of that, everything's an argument. So there's that. Last thing before we jump into these emails, I've got I was brought this Knob Creek small batch bourbon. So we'll do a little whiskey review. It's early for a whiskey review. I've done one for December, but it is December, so let's do a second one real quick. Won't be as wild as the other ones. Man, they're fond of the wax on this. Okay. I have a feeling this might be a little bit better than Fuyu. Smells good. Can smell the wood in this. That bourbony corn smell too. That is a smooth bourbon. It's 100 proof. It's 50% alcohol. Does not taste like it. It's got a little bit of that bite. Just a tiny bit. Oh, that's good. That is very delicious. Anyway, thank you. Thank you to my man who brought this. No dox. Don't want to dox anybody. Give me that. Oh, man. I've got something that's important for today. I'll be right back. Chair Coon, you're better than this. Better than me at this. Okay. Sorry, I got two things in the mail that I needed to... Oh, Cherkun was barely in frame! Oh my gosh, I'm so sorry. Two things in the mail that need to be addressed. This first one is from Siren Jag. Siren Jag sent me... Let's see if you can see that. Some sacred ointment. So, thank you. Thank you, Siren, for the sacred ointment. I will apply the sacred ointment. That's lovely. And then this next one is very appropriate for this stream. I don't know who sent me this. It didn't have a thing in the box. But someone sent me this little stuff thing. And you may wonder what this is, but I'm going to tell you, or I'll just show you because it's on the it's on the tag here. This is oh, here we go. You see that? Yes, they sent me the West Nile virus. which does look a little bit like a lemon, but it's actually West Nile itself. So someone sent me West Nile. Thank you for that. It was a little bit rude. I don't get to breathe the best. Oh my goodness. Okay. So I'm gonna snip these out just like we did last time to protect the to protect the identity of my new email companion. Whoops. So I'm gonna be better at this. Where is... Okay. Where's the... Okay, sorry. It was being weird. It wasn't showing me the whole thing. Here we go. All right, so let's go over to here. Here we go. Here's the email. This is fan mail number 2. This is from the previous sender. So we'll take a picture, or we'll take a look at this. Has Tina posted anything yet? Guys, if Tina had released the transcript, we'd be reading it. So, no. Okay, so this is from the pen pal. Let's take a gander at what he has to say. I'm using a new email. This did come from a different email address, so I'm taking them at their word. I don't like to leave an easy trail for my enemies to discover. I sent you the last email you read on air. I'm actually surprised because most of the people on YouTube either have glow-in-the-dark gatekeepers or are glow-in-the-darks themselves. I would like to respond to the first sheep that called me out in a super chat and said that MGTOW saves lives. MGTOW is like the airbag that deploys just in time before your car slams into a brick wall at 80 miles per hour. What the ignorant fool doesn't understand is that the car he was sold was a cheap piece of shit, and his degenerate wife is on the top of the hill laughing and pointing because she cut his brakes and watched him drive out of control. Each generation of men before him has seceded a little bit of their rights and powers. MGTOW is just resigning yourselves to be the beautiful ones, referred to in the Rat Utopia experiment. Society degenerates and slowly dies, all while the beautiful ones eat, sleep, and groom themselves all day. It's perplexing that despite plenty of room, food, and water, that all the rats end up dead. It brings a smile to my face to know this fool doesn't even realize that I've been here since the beginning. Like the train man in the Matrix, I created this place. Here I am God. I always like putting star in the nicknames given. I thought I would use Stardust until I finally decided on Stardust till I finally decided on Stardusk. I also used to use the name Polaris a lot. I decided to use the name Solaris. I enjoy mythology, so I used Ragnar as well. I put the people in charge in 1999. Didn't I tell you in the first email that I was going to be a social engineer? I know all the MGTOW content better than anyone else. I was the person who invented it. I should know. By the way, Angry MGTOW's dad is a cop, and his brother worked for the State Department. Sandman worked in TV in the Toronto area. I know these people intimately, each and every one of them. MGTOW took root soon after 1999. We knew it was going to come in the 2000s. We knew about 9/11. We knew about everything that's taken place up till now. We had a follow-up meeting with the CIA during the WTF Task Force conference. That is where they decided to launch the culture war and push movements such as Occupy Wall Street and Gamergate. These fools don't seem to understand yet. You want to know why idiots like Richard Spencer are living where they are now? There was an operation called Pioneer Little Europe. It was pitched to the Stormfront community, and they took it hook, line, and sinker. We picked that region of Montana because one of the myths about Hitler, that he went to Montana near Glacier National Park. It isn't true, but that's what we went with. Hitler actually went to South America. One of the main informants was April Gade, who had her 2 daughters sing in a lulzy rock group, Prussian Blue. They later turned into hippies smoking weed for back problems. Back problems plague a lot of the elites. They filed some restraining orders on a few of the overzealous fans. One idiot wanted to marry one of April's daughters. So there you go. That's this one. We'll see the next one. These are a little, like, it's a little bit weird, but you know. Oh, this one's about Zoom. Here's one about Zoom. I feel like he was sending me these while watching the stream. Here we go. Here, this one's about Zoom. A super chat claimed I sound like Zoom. That bastard glows in the dark brighter than his room does down the street. Seriously, you can see his brightly colored room all the way up his street. Zoom can tell the State Department and FBI contact he has to F off. Degenerate Null is only slightly better. I think with time, Null has gotten a little soft. That is cute. Zoom, on the other hand, is a complete sociopath. Doesn't have a conscience at all. Glad to know Null at least has a bit of a conscience. Null might be redeemable. By the way, when I was going through the files while I still had access, there was a file on Noemi Moon, a Playboy bunny from the Ukraine. I thought it odd and funny. It's also funny how the spooks have had files on all these celeb types since the paranoia days of J. Edgar Hoover. You can ask your buddy Gator about Zoom. Zoom was hot on the trail of Ethan Ralph and his associates for a while there. Someone called Zoomy McFly a pedophile. Nick, who do you think the Google is? Who do you think the Google? Alphabet should give you a hint. Facebook and Amazon both have glow-in-the-dark origins as well. He's got 1, 2, 3, 4. I got 5 more of these. I'm only going to read one more, though. Just one more. This is just a little... It's just a little warm-up. We're not going to spend all day on this. I might read some every now and then. This is so weird. This one's kind of on subject. So, sort of. This is about Volney. Well, no, I shouldn't say this is about Volney. This is to Volney. So he has a message. This one's a message for Volney, aka Funimation lawyer. So here you go. You're gonna get some truth on you. This is a message for Volney, the Funimation lawyer. Dear gay boy, I know you're probably too busy filleting the Saudi royal prince, or maybe your CIA handlers. Hint, look at his case history and website. But I would like to let you know something. I know. There's a certain 15-year-old female model who moved from the Bay Area to Texas that attends many cons. She's been in contact with Sabbath for years now. She posted in support of Blasey Ford when it happened on her Instagram. Uh-oh. She might be edging ever closer to speaking to someone. You can tell by the look in her eyes and her recent photos she's dealing with pain. I feel sorry for her. These are all my words, though, and not Nick's. Sabbath, I bet you're getting nervous. We all know that the dark machinations of the heart always slip out. Those audio recordings are who you really are. Much truth is spoken in jest. It would be a shame if the first domino were to fall. Sabbath is a big enough and fat enough one to bring you all down. Ta-ta for now, gay boys. So there's some Volney and Sabbath stuff. Oh, there's one more that I'm going to read just because it's his thoughts on Lemoyne. Okay? This is thoughts on Lemoyne. We got to read that one too. I'm going to skip the other three, but we might revisit those a different time. So, ta-ta for now, gay boys. Real quick, there's a couple super chats. The Dark Knight says, to the degenerate again, thank you, simp/mangina. You don't care about men's well-being nor the divorce rape laws. You spout BS and that only. Men well-being before anything else. At least I don't have a leecher on my back. So that's from the Dark Knight to simp/mangina. And Cathurga says, hey guys, the vigilant Christian here with the satanic Illuminati created by women to avenge Eve. What? As you can see in the picture, Katy Perry is making an okay sign, and we all know that's 3 6s. So yeah, Satanist. Okay. All right. Let me get that last email pulled up. What is happening? I need to call my CIA contacts and ask them to help me translate all this. So these are the thoughts on Lemoyne. The thoughts on Lemoyne. Okay. Lemoyne is involved with the Unitarian Church. Well, that explains a lot, actually. Basically a bunch of filthy, degenerate hippies that believe in a little bit of everything. They believe in universal salvation no matter how many men's rods you take in the anus. I'm going to censor this. This is offensive. I know the real reason Lemoyne got West Nile. He is a pervert gay boy that does what the gay community does in many areas. They meet up in parks and public areas to have sex. Can you get West Nile from This is how Westboro Baptist Church got started, because they got sick of, oh my, figs rectal copulating in the park. Whew. Lemoyne was a power bottom that was getting it in the derriere, to use the French, from dusk till dawn. And a mosquito with West Nile finally bite him while taking it in the poop chute from his gay lovers. This is very explicit. To the super chatter who said the poor gays always get blamed, wham, boo-hoo. Homosexuality is always the sign of societal decay and collapse. It even happened in the Rat Utopia experiments. The Greeks, Romans, and many other societies gave into it. God made them male and female, and a man joins himself to a female to create one flesh and their children. Homosexuality is degenerate, and you'll pay for your filthy, degenerate sin. The Chinese Communist Party will brutalize the F out of you for being gay. Forget white babies, you better make any babies. Communism you think it isn't the communism you're going to get. In many places, such as Romania, abortions were banned and degeneracy was heavily punished. Being single gets you fined by the system. These fat effing ugly feminists that want communism don't understand what will happen to them. After communism takes over, they will immediately kill all opposition. Then they will kill all the subverts like Anita Sarkeesian, Zoe Quinn, and all the university intellectuals. They will kill all of the useful idiots. These ignorant masses don't understand that. There are people who will be deemed too dangerous to re-educate. Both sides are worthless sheep. They don't realize that cultural Marxist subversion is but a stage. All the ideas are BS. It will always be fascist tyranny. The people mean nothing. F you furries. F you bronies. F you subs and doms. F you migtards. F you feminists. F you Thelma Satanists. And F you alt-rightards. God and Jesus are the only way. God didn't want there to be a king or a government. I mean, he kind of did appoint kings and governments. The people in ancient Israel pleaded for a government and a king. That's true. God listened to them instead of being God, apparently. God told them how it would turn out. God is the only God and Jesus is his king. All you other gay boys will burn in the fire of Sodom. You'll be turned into dung on the battlefield. The crows will eat your flesh. You degenerates. So there you go. That's that one. There wasn't much thoughts on Lemoyne other than he thinks Lemoyne got West Nile from being gay. So there you go. As you can see in the background here, we do have Vic's GoFundMe up $266,810. Thank you to Big Boss, Michael Person, Anonymous, and Claude Gamer for your donations. Always appreciated. And I do, again, as far as the transcript goes, you'll have it as soon as I have it. You'll have Chupp's findings of fact and conclusions of law as soon as I do. They're just not done. They're just not out. There's nothing for me to give. I can no longer give. Can no longer do it. But I'm trying to give all that I have just to you. But anyway, so that's where that is. That was just, I got more of those things from that guy, and I thought that was a little bit weird. So let me get, what is this? I don't want that. All right. Let's pull up this case. Oh. Pull it up here. We'll start reading through this. Oh, I should check one more thing real quick. I should make sure this case is still good law, which I can do. One moment. Oh, come on. Here we go. Is this it? Nope. What is my password? Oh my goodness. What? This is the problem with having different passwords stored. I'll have to figure that out. How annoying is this? Sorry. Yeah, what? Why don't I have? How annoying. It works on my phone. Just a moment. We'll just do it on here. I've got the 436 SW third. No, not that. Undo it. There we go. Now search. Search thing. Why is everything terrible? Okay. Sorry, we're getting this. versus. Ooh. Hold on. We've got an interesting development in this case. Oh, okay. So what I had to look up was this case was disapproved by a later case from the Texas Supreme Court, but the grounds that it was disapproved upon were pretty importantly distinguished. They benefit the other party. So I just wanted to make sure. That that what we're going to be reading is relatively good law. I'll tell you what it was when we get there. Just wanted to make sure this was the end. Of it. So here we go. Okay, so what the ruling in Hirsch versus Tatum is the ruling that here we go. Now I'll explain it ahead of time. Okay, so the ruling in Hirsch versus Tatum changes this a little bit. It says, when it is clear from the plaintiff's pleading that the action is covered by the TCPA, the defendant need show no more to apply the TCPA, disapproving of American Heritage Capital LP versus Gonzalez, which is this case. Now, Wick Phillips represents the plaintiff in this case, and so that was we'll see what they say about that. But I'm guessing that the Supreme Court or the appeals court here just must have said that the defendant had to do a little bit more to show that the TCPA needed to be invoked, and then they actually reduced that. So that was not in favor of Wick Phillips here. But here we go. Jeffrey W. Hellberg Jr. Now, where have we seen that name before? Jeffrey Hellberg Jr. can be found. Where was it? I'll pull up the document for you guys so we can make sure this is all very okay, here we go. Where's that name? Oh, here we go. Jeffrey W. Hellberg Jr. So here, this is from the defendant's cross notice of appeal. Jeffrey Hellberg Jr. is, I believe, is he the head appellate counsel for Wick Phillips? Something like that. Let's see who their professionals. We've got Hellberg. Jeffrey Hellberg Jr. is a partner in the litigation section of Wick Phillips and is the head of the firm's appellate section. Okay, so Jeffrey is their appellate specialist. That's why he was on, or he's on the appeal here for the fees, and why he is also on the appeal in this case that we're about to read. So that's the link here. It's also got Brian James Wick, who's obviously Wick of Wick Phillips, and then a couple other characters. All right. So here we are. Let's see. Talon Sears says, "Isn't this guy supposed to be Christian? If so, I find his religious literacy to be questionable. He should revisit Matthew 5 and reevaluate what he's saying about others." Ooh, that's a gauntlet thrown. A gauntlet thrown to the emailer. So there you go. All right. Here is, so this is American Heritage Capital LP is the appellant / cross appellee versus Alan Gonzalez, So right away, we have Wick Phillips trying to oppress a minority. You can tell, well, I'm assuming by the last name Gonzalez. And even if you're a minority either way, because you're either of Hispanic origin or you're a white guy with the last name Gonzalez, which would be a minority as well. Appellee and Dinah Gonzalez cross appellant. So Wick Phillips oppresses minorities and wants to silence their speech. We know that much from this. It's been a while since I've had a good bourbon in my house. I keep getting trash. Oh boy. So, here we go. Let's take a look at this case. So this is the opinion of the appeals court. This is the final resolution of this case. And is well, here we go. Justice Fitzgerald. What is Court of Appeals, Texas for Dallas. So this is the next county over, right? It's not in Tarrant County. No, Tarrant County. American Heritage Capital LP sued Alan and Dinah Gonzalez for defamation and tortious interference with prospective business relationships. Yes, so Wick Phillips was representing American Heritage Capital in a lawsuit against two helpless minorities for their speech. They wanted to silence their speech. AHC non-suited its claims against Dinah. That means they folded their lawsuit, and we'll talk about that in a second. The trial judge dismissed AHC's claims against Allen based on Allen's motion to dismiss under the Citizens Participation Act, Chapter 27 of the Texas Civil Practice and Remedies Code. The judge later awarded Allen attorney's fees and a $15,000 sanction. AHC appeals. Dinah cross appeals the trial judge's failure to hold a hearing on her motion to dismiss under Chapter 27. We affirm the judgment. Okay? This is steel yourselves, friends, and remember how much flack Vic got for doing a lawsuit when, remember what happened to him. Remember what happened to Vic. He lost his convention appearance schedule for the entire year, other than what came back later and what he was able to later book. He lost his jobs at Funimation and at Rooster Teeth. He was drug through the proverbial mud relentlessly for about a month. Actually didn't file suit until April, after what, 2.5 straight months of constant daily defamation from the defendants. Daily attacks on his character where he wasn't good enough to just let die. Vic wasn't allowed to even die in peace by these scumbags who went on a months-long tirade against him. Now, let's compare that to what the evil Gonzalez family did to a giant bank. Okay. AHC alleged the following facts in its live pleading. AHC is an online mortgage lender. Dinah contacted AHC in August 2011 about obtaining a home loan. According to AHC, now this is the plaintiff's side of the story. According to AHC, Dinah misrepresented certain information in her application and delayed in providing certain required information and documentation to AHC, delaying the process. AHC's loan commitment to Dinah expired on October 14th, 2011, before Dinah and the seller of the house in question could close the sale. After that date, AHC informed Dinah that it would not be able to fund the loan because AHC had not received all necessary documents and information from her. Defamatory statements about AHC began to appear on several websites. AHC sued Dinah for defamation and tortious interference on October 27, 2011. Dinah filed a motion to dismiss the case based on the recently enacted Chapter 27 of the Civil Practice and Remedies Code. Chapter 27 creates an early dismissal mechanism intended to, quote, encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, while simultaneously protecting the rights of persons with meritorious claims. See Civil Practice and Remedies Code, annotated 27.002. Statutes like Chapter 27 are commonly known as anti-SLAPP statutes because they are intended to curb strategic lawsuits against public participation. Now that was how the plaintiff framed it. In her motion to dismiss, Dinah asserted that her husband Alan had posted the internet statements in question. AHC then filed its first amended petition, adding Alan as a defendant. Alan filed his own motion to dismiss under Chapter 27. AHC non-suited its claims against Dinah soon thereafter. On March 5th, 2012, the trial judge held a hearing on Alan's motion to dismiss. On March 6th, the judge signed an order granting the motion to dismiss and setting a hearing for March 9th. To determine the amount of damages and costs to be awarded against AHC. That hearing was postponed to March 30th, and it took place over 3 separate days, March 30th, April 5th, and April 13th. On April 14th, 2012, the judge signed a judgment awarding Alan attorney's fees of $15,616, plus additional amounts as conditional appellate fees, and a sanction of $15,000. So, let's see where we go from here. Are you noticing some similarities, right? AHC filed a request for findings of fact and conclusions of law on May 3rd and a motion for new trial on May 11th. The judge signed findings of fact and conclusions of law on June 5th. AHC filed its notice of appeal on June 11th. Dinah filed a notice of cross appeal on June 25th. So this appeal seems like it was completely untimely, but I think the appellate court took it for a specific reason. If its notice of appeal was on June 11th and his judgment was done on April 14th, that's a long time. But let's follow along with what happened here. AHC has filed a motion to dismiss Dinah's cross appeal. Oh wait, she filed her cross appeal on June 25th. As untimely filed. So appellate jurisdiction. I know this is kind of thick reading, and I'll stop at the relevant parts. And we'll drag them out. Because there are some similarities here. AHC raises 2 arguments that challenge our jurisdiction over this appeal. First, in AHC's second issue on appeal, they argue the March 6th order granting Alan's motion to dismiss was a final judgment and that the April 14th final judgment is therefore void because it was signed after the judge had lost his plenary power. So let's pay attention here. The judge issued a judgment and then said, we want to have a hearing on fees. Wick Phillips argued that the fees are invalid because the judge didn't have the authority to make them. Now, did you notice Lemoyne actually suggested that that was what Ty was going to do? Do you remember that? Lemoyne said that that's what they thought the plaintiff would do. The plaintiff would make that argument based on their early appeal, even though the early appeal said they intended to appeal the fee decision when it was done. Right? So that clearly wasn't part of the argument ever. They just determined that they would file the notice of appeal and then suggest that they would amend and add the fee appeal in when the fee appeal order was granted. So here we go. Let's see. If AHC is correct that the March 6th order was a final judgment, it necessarily follows that AHC and Dinah's notices of appeal were untimely filed, and we must dismiss the appeal. Second, in its motion to dismiss Dinah's cross appeal, AHC argues that Dinah's notice of appeal was untimely in any event because her notice of appeal deadline began to run either on January 18th, 2012, when her motion to dismiss was supposedly denied by operation of law, or on January 30th, where the trial judge signed the order granting AHC's non-suit of its claims against Dinah. Jurisdiction over the appeal as a whole. Appellate jurisdiction is never presumed. If the record does not affirmatively demonstrate that appellate jurisdiction is proper, the appeal must be dismissed. A timely notice of appeal is a jurisdictional prerequisite. Generally, the notice of appeal is due 30 days after the judgment is signed if the time is not extended by the timely filing of certain post-judgment documents. This was before they filed the expedited appeal process, or added that to the lawsuit, I believe. The general rule, which governs AHC's appeals in this case, is that an appeal may be taken only from a final judgment. A judgment is final for the purposes of appeal if it disposes of all pending parties and claims in the record, except as necessary to carry out the decree. If, as in this case, there has not been a conventional trial on the merits, we do not presume that a judgment is final. An order or judgment is not final for purposes of appeal unless it actually disposes of every pending claim and party, or unless it clearly and unequivocally states that it finally disposes of all claims and all parties. There must be a clear indication that the trial court intended the order to completely dispose of the entire case. If there is any doubt as to a judgment's finality, the question must be resolved by determining the trial court's intention as gathered from the language of the order and the record as a whole, aided on occasion by the conduct of the parties. The intent to finally dispose of the case must be unequivocally expressed in the words of the order itself. I know this part is boring. It gets a little bit, it picks up a bit in a second here. The pertinent facts follow. AHC's live pleading included claims against both Dinah and Alan. Dinah and Alan did not file answers. Instead, they each filed a motion to dismiss under Chapter 27. In their motions, Dinah and Alan sought not only dismissal of the action, but also court costs, attorney's fees, expenses, and sanctions. On January 30th, the trial judge granted AHC's partial non-suit and dismissed AHC's claims against Dinah. Now, this is different now. You can no longer non-suit a claim after the TCPA is filed to avoid the TCPA. You can't do that anymore. Once a TCPA is filed, you are being brought in to hear on the TCPA. Period. Like that's a thing that must follow after this ruling, but that's how that is handled now. The trial judge granted AHC's After hearing Allen's motion to dismiss on March 5th, the trial judge signed the March 6th order, reciting that Allen's motion to dismiss is hereby granted and this action is dismissed against defendant Alan Gonzalez with prejudice to its refiling. The order did not dispose of Allen's request for cost, fees, and sanctions. So similar to Vick's case. To the contrary, in the last paragraph of the March 6th order, the judge set a hearing on March 9th, 3 whole days later, to determine the damages and costs to be awarded to defendant Alan Gonzalez pursuant to 27.009 of the TCPRC. The word final does not appear in the order, nor does the order contain a statement that it finally disposes of all claims and all parties. That's actually a little bit different from Vick's case. If you'll remember, at least they argued that in Vick's case, there's a little bit of wording issue. Oh, I can pull it. I can pull this stuff up. Here we go. Where is Where is it? It's right up here. So here's the difference. If we can pull these two things. The word final does not appear in the order, nor does the order contain a statement that it finally disposes of all claims of all parties. What it said in here, which this is what Martinez Sue stated at the hearing, is the court finds that the 3 motions should be and are granted in full. So that's what they argued. That is ambiguous as to whether or not the order is final. And they asked Chup whether or not the order was final. And Chup said, I don't know. Chup didn't know if his own order was final. And he said, you'll have to ask the appeals court. Well, we now know that the appeals court has decided for whatever reason to not dismiss the TCPA. But this would be a little bit of a difference in the wording that they're talking about here, I believe. Because it said, yeah, it's hereby granted and this action is dismissed with prejudice to its refiling. It doesn't say granted in full or anything like that. Further, the parties and the trial judge did not treat the March 6th order as a final judgment because they continued to litigate the case more than 30 days after the signing of that order without the filing of a deadline extending motion under Texas Rule of Civil Procedure 329B. Indeed, on March 26th, the trial judge signed an order setting the case for trial in October of 2012. See, judges don't even know when they've dismissed cases, so that's great. So here we go. The March 6th order does not appear to be a final judgment under layman. It does not contain a clear indication that the trial judge intended it to dispose of the whole case, nor is such an intent unequivocally expressed in the words of the order itself. Although the order dismisses AHC's action against Allen, it also sets a future hearing to determine the damages and costs to be awarded to Allen. Damages and costs, and the phrase encompasses not only court costs, but also attorney's fees and sanctions. Thus, the order indicates that the trial judge intended it for it not to dispose the entire case. This is actually similar to Vick's case, if you remember, because the judge did say to bring paperwork by a certain deadline for the fees and sanctions, which tends to show that it is not a final judgment under layman. Cases comparable to InterHealth Incorporated. In that case, we were confronted with judgment that contained a handwritten notation that the issue of whether an award of attorney's fees is equitable and just remains pending. We held that the continued pendency of the claim for attorney's fees made the judgment interlocutory and not appealable. In the instant case, the judge's statement of intent would take up Allen's request for attorney's fees and sanctions at a future hearing would seem to render the March 6th order interlocutory. Okay, so apparently, again, in this case, the appeals court, for whatever reason, decided that Vick's order was not interlocutory, or his appeal was not interlocutory, and everything is fine to move forward. AHC argues that a pending motion for sanctions, like Allen motions for costs, fees, and sanctions, does not affect the finality of an order that would otherwise be final. That's the opposite of what Lemoyne was arguing here. But Lemoyne learned that they were wrong here. To his credit, Lemoyne learned that they were incorrect in this case. All right. Let's see. But more recent authority from the Texas court contradicts AHC's position. In Kreitz versus Collins, the court stated a judgment dismissing all the plaintiff's claims against the defendant, such as an order of non-suit, does not necessarily dispose of any cross-action, such as a motion for sanctions, unless specifically stated within the order. Blah, blah, blah. This is all just really thick and boring part about the jurisdiction. Let's see. AHC also relies on our Straza decision, which we reaffirmed a rule that an otherwise final judgment is final even if it does not address court costs. Straza is distinguishable because it concerned only an omission of an award of court costs from an otherwise final judgment. The March 6th order in this case not only failed to award costs, but set a further hearing. So there's the difference there. We conclude that the March 6th order in this case was not a final judgment. Allen's motion for sanction was already pending when the trial judge signed the March 6th order of dismissal, and the order did not fully resolve the motion for sanctions. This prevented the order from being a final judgment. Moreover, the March 6th orders express reservation of the issues, blah, blah, blah. So because the March 6th order was not a final judgment, the April 14th final judgment is not void, and we have jurisdiction over this appeal. We reject AHC's second issue on appeal. Okay. That's kind of the boring jurisdictional one. It's a little bit ironic that, you know, they had this sort of similar situation pop up. Although for them they reject that jurisdictional question and say that they do have jurisdiction, but it's a different question in Vick's case, but a similar set of facts. But again, the appeals court in Vick's case has already determined that the motion to dismiss was denied. So jurisdiction over Dinah's cross appeal. This is the same types of arguments, and I think we're going to skip this section because most of this law is not good anymore. They had like a 60-day deadline to appeal and all of this stuff. This is all actually bad law because now, had they non-suited, if you non-suit a case after TCPA is filed now, they still go through with the TCPA motion, and you can still lose attorney's fees and sanctions and all of that stuff if the case is proper, if it's an anti-SLAPP case. What they didn't want is this, right? The court didn't want a mortgage lender to take two poor saps who are trying to borrow money from them and sue them, and then when the TCPA is filed, motion for a non-suit and make them have to spend money on an attorney, give them all the stress and all of that stuff and flex on them, and then just withdraw with no risk to themselves. They didn't want that to happen. So the court eliminated the ability to do that. Because of that, I'm not going to read this. This is all irrelevant at this point. Let's get into the appeals. The appeal itself. Because remember, AHC is a mortgage lender represented by Wick Phillips, the firm Lemoyne works for now, and that has been representing Monica Rial, Ron Toye, and presumably Funimation. Or, well, I guess technically they're representing Kessler Collins, who says that they're representing Funimation. It's a little bit fuzzy on that one. But here we go. AHC's appeal. We turn to AHC's 4 remaining issues on appeal. In its first issue, AHC complains that the trial judge erred by hearing Allen's motion to dismiss after the statutory deadline for the hearing had expired. In its third issue, AHC contends that it met its burden of proof under Chapter 27, so the trial judge erred by granting Allen's motion to dismiss. Its fourth and fifth issues, AHC complains about the award of attorney's fees and sanctions. So the timeliness. In its first issue on appeal, AHC argues that the trial judge erred by hearing Allen's motion to dismiss on March 5th, which was 60 days after Allen filed and served the motion. AHC relies on the version of Section 27.004 applicable to this case, which provided as follows: a hearing on a motion to dismiss must be set not later than the 30th day after the date of service of the motion, unless the docket, conditions, or the court require a later hearing. AHC does not explain what consequences should follow if we were to conclude that the hearing was untimely under Section 27.004. Now, what happens now, if the hearing is untimely and there's not a reason, not for good cause, then the TCPA doesn't matter. We cannot address AHC's first issue on appeal because the record does not demonstrate preservation in the trial court. AHC does not explain in its appellate briefs how it preserved this alleged error. AHC filed its response to Allen's motion to dismiss on March 5th, the date of the hearing, but the response contains no objection to the timeliness of the hearing. We do not have a reporter's record from the March 5th hearing. The 2 volumes of reporter's record from subsequent hearings that we do have contain no objections from AHC regarding the timeliness of the March 5th hearing, nor did AHC raise this argument in its motion for a new trial. Accordingly, AHC may not raise this argument on appeal. This is very important part of appeals, is that you have to preserve the issue for the appellate court to address it. You can't just ignore it. Now, sometimes you're prevented from preserving an issue, like you try, but the court tries to not let you, or some operation of fact prevents you from doing it, but you have to make an effort to preserve the issues on appeal. And most importantly, you have to then bring them up on appeal and talk about how you did try to preserve it if the record doesn't support it. Like, we did this, but this didn't happen. In Vic's case, they're going to have this interesting little line by Chupp where he told Ty to stop standing up and objecting at the hearing. It's like, stop objecting, stop standing up. And so, they'll have the ability to at least make the claim that they're preserving issues for appeal all throughout the hearing, but the judge commanded them to stop doing it, that's appealable, that the judge shouldn't have been able to do that, but that's why the record might not have some of those things at the hearing itself. The judge told us to stop. Like, the judge commanded us to do this. How are we supposed to preserve stuff if the court won't even let us? So anyway, let's but that's the important part of preserving issues on appeal. This may have been an error that they could have fixed, but they didn't do anything. You could still file your response, but you could file your response with an objection. You'd say, we're objecting to the timeliness of this, but here's our response as well. Propriety of the dismissal of AHC's claims. In its third issue on appeal, AHC argues that the judge erred by granting Allen's motion to dismiss because AHC successfully established a prima facie case for each essential element of the claims it asserted against Allen, namely libel and tortious interference with prospective business relationships. All right, guys, this is the part of the lawsuit that I found hilarious, because we're about to read what the libel was and what the tortious interference was. And remember that Wick Phillips, Lemoyne, and Law Twitter all said that Ty was dumb for bringing this case on behalf of Vic. Now, you know the set of facts for Vic. You guys know that. What you don't necessarily know is these sets of facts, and that's what we're going to cover now. In the context of a Chapter 27 motion to dismiss, the movement bears the initial burden of showing by a preponderance of the evidence that the claimant's legal action is based on, relates to, or is in response to the movement's exercise of the right of free speech, the right to petition, or the right of association. That hasn't changed. AHC does not contest that Allen satisfied his burden under Section 27.005B. Thus, the burden shifted to AHC to establish by clear and specific evidence a prima facie case for each essential element of the claim in question. Generally, a prima facie standard requires only the minimum quantum of evidence necessary to support a rational inference that the allegation of fact is true. We reviewed de novo the trial judge's determination that AHC failed to carry its burden under Section 27.005C. Libel. Two essential elements of libel are that the defendant made a defamatory statement about the plaintiff and that he did so in written or other graphic form. A statement is defamatory if it tends to injure the subject's reputation, to expose him to public hatred, contempt, ridicule, or financial inquiry, or to impeach his honesty, integrity, or virtue. Notice that a statement may be false, abusive, unpleasant, or objectionable without being defamatory in light of the surrounding circumstances. Whether a statement is capable of a defamatory meaning is initially a question of law for the court. Moreover, to be actionable, a statement must assert an objectively verifiable fact rather than an opinion. We classify a statement as fact or opinion based on the statement's verifiability and the entire context in which the statement was made. Whether a statement is a statement of fact or opinion is also a question of law. AHC relies on the evidence of 3 statements by Allen on various internet websites to support the elements of AHC's libel claim, and we conclude that none of them constitutes an actionable defamatory statement of fact. 3 statements by Allen on various internet websites. How many did we have against Vic? 400 from Ron Toye alone, right? From Toye alone, 400 statements. Markey had a couple statements, 2 or 3 I think, that were alleged to be defamatory. Rial, one of them, of course, was like a narrative story. Rial had several as well. But let's read the statements. We have them. Shockingly, we have them. First, AHC points to the following statement, quote, "The guy that was supposed to handle closing could barely speak English." That's it. Wick Phillips, right there. Barely speak English. That's the defamatory statement. Remember Law Twitter furiously self-pleasuring over calling Vic a pedophile not being defamatory. Over calling Vic a rapist not being defamatory. Over saying Vic assaulted someone not being defamatory. Look, assaulting people, that's not defamatory. Barely speak English. We conclude that this statement did not rise to the level of being defamatory. To be defamatory, a statement must tend to injure the subject's reputation. Oh, and that's Gonzalez saying it. Oh, he gets a card. He gets an English card automatically. We conclude that this statement did not rise to the level of being defamatory. To be defamatory, a statement must tend to injure the subject's reputation, expose him to public hatred, contempt, ridicule, or financial injury, or impeach his honesty, integrity, or virtue. This statement, although plainly intended as criticism, is not egregious enough to impeach AHC's honesty, tarnish its reputation, or expose it to ridicule or financial injury. It is akin to the statement in Double Diamond that a real estate development lacked adequate roads and adequate water and sewer systems. Although the statement constituted opinionated criticism, that's a boomer reference. We held as a matter of law that the statement was not egregious enough to be defamatory. Moreover, we conclude that the statement complained of by AHC is non-actionable statement of opinion because it cannot be objectively verified. Whether someone can barely speak English is a matter of subjective opinion, because what one person may view as non-proficient English may be completely acceptable to another person. AHC's evidence of this statement is no evidence of a defamatory statement of fact. So that's the first one. 2 to go. Next, AHC relies on these statements. Chris and everyone I talked to at this company were incompetent. They reviewed my credit rating and promised a quick close. Then the list of things got longer and longer. So that's the second statement right there. We first considered the assertion that Chris and AHC's other employees were incompetent. We have held that statements implying that someone is incompetent are non-actionable opinions because they are not objectively verifiable. Not competent, y'all. Pedophile, assaulting hundreds of women, rapists. Those are too stupid for defamation. But incompetent, that's reasonable. Consistent with our opinion in Robertson, we hold that a statement expressly calling someone incompetent is a non-actionable statement of opinion. The other statements amount to implicit criticism of AHC for requiring additional things after promising a quick close. These statements are not egregious enough to be defamatory. In sum, we conclude that these statements are no evidence of a defamatory statement of fact. Now, mind you, they would have to assert damages of this. These aren't per se defamatory, even if they were defamatory, which they're not. Finally, AHC relies on the following statement. At one point, they asked for an explanation of $200 out of a $30,000 deposit to make sure we were not borrowing money for closing. It was my son's birthday money, for God's sakes. We conclude as a matter of law that this statement is not defamatory. Yes, that's it. At one point, they asked for an explanation of $200 out of a $30,000 deposit to make sure we were not borrowing money for closing. It was my son's birthday money, for God's sakes. At most, the statement communicates the author's opinion that AHC was excessively demanding and requiring information to support the loan request. Statement cannot fairly be read to injure AHC's reputation, expose AHC to public hatred, contempt, ridicule, or financial injury, or impeach AHC's honesty, integrity, or virtue. Moreover, whether a lending business is excessively demanding is not objectively verifiable, but rather a matter of subjective opinion. AHC's evidence of this statement is no evidence of a defamatory statement of fact. So those are the 3 statements that Wick Phillips, they sued someone over this. Because AHC produced no evidence of any defamatory statements of fact, By Allen, the trial judge correctly dismissed AHC's libel claim. Tortious interference with prospective business relationships. The elements of tortious interference with a prospective contract are a reasonable probability that the parties would have entered into a business relationship, an intentional malicious intervention, or an independently tortious or unlawful act performed by the defendant with a conscious desire to prevent the relationship from occurring, or with knowledge that the interference is certain or substantially likely to occur as a result of its conduct, a lack of privilege or justification for the defendant's actions, and 4, actual harm or damages suffered by the plaintiff as a result of the defendant's interference. Thus, to survive Allen's motion to dismiss, AHC had to establish by clear and specific evidence a prima facie case for each of those essential elements. The element of damages is dispositive. That means that it resolves the case. In its brief, AHC fails to identify any evidence of damages. Indeed, AHC's entire argument on the element of damages is a single sentence asserting that Allen's conduct has already caused and will continue to cause AHC significant damages. Remember, these people wanted exact numbers of damages for each contract that was breached, each contract that was interfered with, each prospective business relationship that might have been interfered with. They wanted exact numbers of everything. Despite not being able to really know or testify to exact numbers without an expert, they wanted all of that. And these guys just said they've gotten damage and they'll get more. That's it. That was Wick Phillips' argument. Remember these people dunking. Even when specific damage was shown throughout the complaints, at the hearing, the specific damage of he had to pay for security, his table was moved. This is in reference to Kamehacon. Those things happened. He lost all these contracts. Those are damages. But, there's that. We want more evidence. That's what they provided here. AHC provides no record citation and support. We will not comb the record for evidence of damages without guidance from AHC. This is some citations to different cases that basically say that the appellant has the burden in their appellate brief and potentially at the appellate hearing to direct the appellate court to where specifically in the record they need to look to find each thing. So my guess is when this stuff actually gets to a brief, there will be an appendix attached to the brief with a reference to each specific place in the record. The appellate record, if you remember, is being built by each appellant. They file their notice of appeal, and then with the appeals court, they mark out specific documents and specific things to be added to the record. And yes, you have to pay for all of them. By page. It's very, very expensive to do that, especially now we've got, the record in this case is something like 3,000 pages. So all of those things though are included. And then in your brief and in your oral argument, you have to be prepared to direct the appellate court to the specific spot. It can be in the record. You just have to tell them where in the record it is. Here, they didn't do that. Citing Barnett versus Koppel, an appellate court has no duty to search a voluminous record without sufficient guidance from an appellant to determine whether an assertion of reversible error is valid. So that's just a procedural thing for the appeals court. You have to tell them where to find it. AHC has not shown that it provided any evidence of the essential element of damages. Accordingly, we will not disturb the trial judge's dismissal of AHC's tortious interference claim. Conclusion: third issue on appeal is without merit. Now let's look at what they argued about attorney's fees, because there's a little bit of irony in here. In its fourth issue on appeal, AHC contends that the record does not support Allen's recovery of $15,616 as attorney's fees. AHC argues that the award improperly includes attorney's fees incurred before AHC joined Allen as a defendant in December 2011. AHC also argues there's no evidence Allen actually paid or incurred any amount as attorney's fees. And we generally review a trial court's award of attorney's fees for abuse of discretion. Sufficiency of the evidence that Allen paid or incurred any fees. We address AHC's no evidence argument first. A trial judge who dismisses an action under 27 shall award to the moving party reasonable attorney's fees incurred in defending against the legal action as justice and equity may require. We find no cases interpreting this particular statute, but in a similar context, we have construed the word incur to mean to become liable to pay. AHC argues there is no evidence that Allen incurred any attorney's fees in the course of defending this lawsuit. According to AHC, Allen's evidence does not show that Allen ever agreed to pay attorney's fees, became liable to his attorney's law firm for fees, or paid any money to that law firm. Allen responds that the evidence sufficiently shows that Allen both incurred and paid the fees awarded by the trial judge. The evidence concerning Allen's attorney's fees consisted principally of an affidavit by Allen and Dinah's attorney, David Odenz, a contesting affidavit by AHC's attorney, Jeffrey Hellberg, and a collection of 5 invoices from Odenz's law firm to Allen and Dinah. We first agree with Allen that the evidence adequately shows that he agreed to pay Odenz and his law firm for legal services in the case. I mentioned this before. The judge isn't actually concerned typically with how much of the fee has been paid. Like, the payment of the fee isn't the issue. The issue is what fees are reasonable. Otherwise, you could just pay $2 million and say that they're reasonable fees. Or you could, be billed a huge amount and pay only a small fraction, and that automatically becomes reasonable because you paid it. That's a problem. Reasonable attorney's fees, you incur fees. You incur the liability to pay for the fee. And that becomes between you and the attorney. What you actually pay to that attorney doesn't really matter in an award for what is a reasonable attorney's fee. It doesn't matter. The award is what attorney fee is reasonable here and that they incurred. Incurring it is the act of becoming in debt to it. So I mentioned this before. Lemoyne, did allegedly say in court that if Judge Chupp didn't award him the full fees, would he bill his clients? And he said yes. Well, yeah, he'll bill his clients, but whether or not his clients end up paying it is a different question that is irrelevant to the fee question. It's just funny, right? Like, that part's just funny. But I am under no illusions that Monica and Ron can actually pay $280,000 to Lemoyne, and good luck getting an insurance company to agree to that amount. He clearly was inflating the costs as he has to inflate his flaccid ego. Let's see. My services and services of Settle Powell were and are necessary to the expenses incurred and reasonable to the plaintiff, blah, 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 blah. To this evidence, we may add Odenz's subsequent description of the legal work he and others actually performed on the case and the existence of the invoices directed to Allen and Dinah. The evidence, viewed as a whole, gives rise to a reasonable inference that Allen and Dinah did in fact retain, i.e. make an agreement to pay Odenz and his law firm. We also agree with Allen that the evidence adequately supports the proposition that Allen also incurred liability for and paid for legal services of Odenz and his law firm. Explain what were performed, how much time was spent on those services, and what the relevant hourly rates were. As of the date of this affidavit, Mr. Alan Gonzalez is current in the payment of attorney's fees invoiced to date. This is some evidence that Allen actually paid fees to Odenz and his law firm, which in turn tends to show that Allen incurred or became liable for those fees. In opposition, AHC relies on 5 invoices from the law firm to the Gonzalez, one for each month from November to March. Each of the first 4 invoices contains an itemization of fees and expenses, recites a credit adjustment in the exact amount of the combined fees and expenses, and concludes, total for this invoice, $0. Last invoice is dated March 9th. It contains an itemization of $468 in fees, $29.37 in expenses, and it concludes, total for this invoice, $497.37. AHC argues that the invoices do not reflect that Allen ever actually paid or owed the law firm anything except the final invoice. We disagree. It appears that all 5 invoices were generated after March 9th, 2012, because each invoice concludes with a reference to one open invoice for this matter dated March 9th, and each invoice also recites a balance due. Each invoice except the last one reflects that the fees and expenses for that invoice were exactly offset by a credit adjustment in the appropriate amount. AHC's inference that the law firm simply wrote off those fees and expenses is not reasonable, particularly in light of the then current March 2012 invoice seeking payment of almost $500 in fees and expenses from the Gonzaleses. It's very possible that the Gonzaleses didn't pay a dime of this, right? Like the appellate court's giving a wink and a nod to this one, but all of the invoices were generated after March 9th and referenced a March 9th invoice that was open, but all of them just say paid, credit applied. It's very possible that they were not paid. By contrast, it is reasonable to infer that Allen had paid the first 4 invoices so that when Oden's law firm later generated copies of the invoices for AHC's inspection, these invoices reflected those payments as credit adjustment and the balances owed on those specific invoices as 0. I mean, credit adjustment may be a payment, it may not. But, you know, too bad. It's not, again, it's not about what was paid. It's really not. It's about what is incurred, what is owed, what liability they had, and it's about what's reasonable. Fees incurred prior to the joinder of Allen. In AHC's other argument under issue 4, it argues that Allen cannot recover attorney's fees incurred before AHC joined him as a defendant in the lawsuit. AHC argues as a matter of statutory interpretation that fees and expenses incurred before it joined Allen simply cannot be reasonable attorney's fees. Look at these guys. Look at Wick Phillips here trying to determine what is a reasonable attorney's fee. Oh, a fee from before they were joined to the lawsuit. Who would talk to a lawyer before they were in a lawsuit? Allen responds that the affidavit shows that the most of the legal services provided to Dinah before Allen was joined were also preparatory to and necessary for legal services performed. Oden's also testified that if he segregated out the fees attributable solely to Dinah's representation, reasonable and necessary fees incurred in Allen's defense were $15,616. That is the amount the trial judge awarded Allen. Let's see. We first review the relevant evidence. On October 18th, 2011, the president and majority owner of AHC, Naushad Parsla, sent Dinah an email demanding she remove the allegedly defamatory internet postings and threatening legal action against her. For example, the email includes a statement, "My second free advise is for you to get a good lawyer in the Dallas area as the venue for lawsuit has already been set in Dallas County, Texas. See attached rate lock confirmation and agreement by you and read it carefully." On the same date, Allen conferred with his and Dinah's attorney for the first time, and Allen began to incur attorney's fees for services relating to AHC's email. On October 27th, AHC sued Dinah under the mistaken belief that she had posted the messages in question. On December 13th, AHC filed its amended petition joining Allen. Yeah. They got fees from back in October. Incurred in, next we analyze the language of the statute. It allows a successful movement like Aan to recover his reasonable attorney's fees incurred in defending against a legal action. We must construe this provision liberally. The questions presented are whether the fees awarded must be limited to fees incurred after the successful movement was formally joined the lawsuit, if not, whether Aan's, they just decided to stop calling him Allen. Aan's fees incurred before December 13th are recoverable in the particular facts of this case. Okay, so a bunch of boring stuff here. We conclude they permit a successful movement to recover attorney's fees incurred in a defense of a cause of action, even if the fees were incurred before the movement was actually sued. Of course. So the attorney's fees are good. Yeah. And reasonable. Fifth issue on appeal. AHC contends that there is no evidence to support the amount of sanctions awarded by Allen to the trial judge, which was $15,000. A trial 27.009 prescribes that a court that dismisses a legal action shall award the movement sanctions against the party who brought the legal action. Blah blah blah. Trial judge in this case made a general finding that a sanction in the amount of $15,000 will be sufficient to prevent AHC from bringing similar actions to this action. AHC contends that there is no evidence to support this finding. Allen argues that sanction amount was supported by the evidence. First, he points out that the attorney's fees for $15,616. Trial judge acted reasonably by concluding the sanction a similar amount would deter them from bringing a similar action in the future. Man, they got off lucky. An also points out in Prosla's affidavit and deposition testimony showing that AHC made a net profit of about $111,000 in 2009, $105,000 in 2010, as the date of Prosla's April 12th, 2012 deposition. He did not know what AHC's net profit was in 2011, but he guessed it would be between $130,000 and $200,000. He also testified his salary in 2011 was $90,000. That is, paid his wife and daughter a total of about $17,000 in 2011. An also directs our attention to an email that Prosla sent to Dinah when he was under the belief that she had posted the messages. Email contains passages such as, "You started this, you can end it. Otherwise, I will end it for you, and it won't be pretty." Given this evidence, we conclude that a reasonable trial judge could have determined that a $15,000 sanction was appropriate. AHC argues it was not necessary to deter them from filing future lawsuits because there was evidence showing it was not in AHC's best interest to threaten its clients or file lawsuits. AHC could not survive if it treated customers unfairly or engaged in time-consuming lawsuits. But you did, though. Why didn't Wick Phillips advise them against this course of action? The wise lawyers of Wick Phillips, shouldn't they have advised them that they couldn't afford this? AHC also points to evidence that it never sued anyone else before and that it was a difficult decision for AHC to file a suit. It's the trial judge's prerogative to weigh this evidence along with all the other evidence in determining, as a matter of description, how large the sanction needed to be to accomplish its statutory purpose. Moreover, we note that An argued for a sanction in the range of $45,000 to $60,000, so the trial judge awarded a sanction that was substantially smaller than the one sought by An. Why can't they type Allen? Oh, the typing gets worse. You can tell the person typing up this opinion got drunker as the night went on. We include the sanction as $15,000 was fine. Dinah asserts the trial judge erred by not conducting a hearing on her affirmative claims for relief under Chapter 27. Oh, yeah. See? These are the pertinent facts. She filed her motion to dismiss. We reject her issue on cross-appeal. Her sole complaint is that the trial judge did not conduct a hearing on her affirmative claims under Chapter 27, but the record refutes her claim. Trial judge held a hearing on Chapter 27 motion on December 19th. The judge continued the hearing until January 30th, on which date the hearing on Dinah's motion reconvened. At the conclusion of that proceeding, the judge signed the order of non-suit and refused to entertain any relief sought by Dinah in the action. In short, record establishes that Dinah's cross-appeal issue is without merit. Trial judge did, in fact, hear her motion on 2 different dates. Dinah does not complain about the judge's refusal to make an express ruling on her motion. The denial of her motion by operation of law or the conclusive denial. So this is the section that was actually overturned later. That's what I was talking about. Now, when you have a current TCPA motion, you can't just non-suit it. They have to hear the TCPA. Once it gets, otherwise you'd have people abusing the system. So that's the decision that was, or that's the part of this description or this decision that was overturned in Hirsch versus Tatum. So there you go. We affirm the judgment of the trial court, blah, 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 blah. And then here's the footnotes. So that's that, guys. That's where we are. I read this, I thought it was funny because here it is, Wick Phillips, the greatest law firm of all time, arguing that those 3 statements were defamatory, sufficient to file suit. They represented this company. Who was it? Let's see who is on the actual case. I wonder if I can find this. The underlying case. Oh, come on. Let's see. Here we go. No, I don't. No, we don't have it. Rats. I was hoping we'd have the undercourt documents just readily available. I'll have to look for them. I was just curious who was the attorney at the lower court. But we'll see. But, let's see if I can find it real quick. Let's see. Search for find my case. Find this one? Can we find it? Oh, we do have it here. See what documents we have. What do we have? Here's the brief. Motion to dismiss filed. Brief. Let's brief. See what we have here. Index of appendices. Let's see. Sanction order, order granting, findings of facts, notice of non-suit, order granting non-suit. See. Hold on. Trying to find this Helberg affidavit. Who wrote the documents here? David Odenz. These are all exhibits now. Oh, were these so these were the yeah, these were the attorneys on the case. So the attorneys listed on the case itself are Brian Wick, Jeffrey Helberg, Seema Tendulkar, and Meredith Perry. So there we go. They're the counsel for the plaintiffs in this case. I'll have to look and see if I can dig up the existing suit at some point. Might be kind of funny to look at their filings and see how they went. Anyway, I'm not going to sit here and stare at that. That's too much. So, why did Wick Phillips want to grind Alan into dust? That's a good question. Good question. You sent it to me on Discord? Wait, what? Oh, you have the original? Let me open this real quick. Plaintiff's original petition. Okay. Interesting stuff. All right. I'm not going to read this right now, obviously. We're actually going to wrap up the stream pretty soon here. I should note the streams in December are probably going to be a little bit shorter than normal, other than the birthday stream was long. But one, I'm not going to push through when there's not as much content in these cases we're following. I know people are really busy in December, and I'm not going to just put out like multiple hours of nothing. Again, other than my birthday stream, which I make no apologies for. But if there's not a ton to cover on a particular night, we're not going to cover a ton. And I don't have much more to do tonight. We're going to go through the chats. We're going to wrap up the stream. I'm going to go over on Twitch and have a good time. I think Keck and I are going to play Keck7Go, one of my Discord moderators, and I are going to play a game together. And you guys can join us for that. It should be fun. But other than that, I'm not gonna just sit and like pound out hours of YouTube rambling. Look for in the upcoming time here, we're gonna be talking about Virginia very, very soon. There may be a full live stream on Virginia. We may be talking about some of this Trump stuff if it gets really interesting on the impeachment. I mean, the impeachment vote, of course the Democrats are going to do it. I didn't really think there was much question, so much as a matter of when they would do it. But impeachment there's just not a lot of structure that actually exists. But one thing to note, I mean, impeachment is political. It really isn't. There isn't much that the courts can do to intervene. There is no appeal of the impeachment detailed anywhere. Once the Senate votes you out, you're out. The Senate votes you in, you're in. They could always impeach you again, I guess. But they're expending a massive amount of political capital on this impeachment. It's a gamble. So we'll see how it goes for them. Good Lord. Not enough allergy meds in the world. So, but we're gonna be talking about Virginia very soon. Look for some short. I'm gonna start putting out some. I know I've said this before, but I'm gonna actually do it. Some very short recap videos on the Vic stuff, covering like very specific issues, using hopefully some of the transcripts. I think that's gonna be some content you'll see as the live streams are maybe a little less frequent while I'm on vacation. I don't know if they'll be less frequent, but they may be. So you may see videos instead of a live stream, for example. Go ahead and check those out. It is December. I know how it goes. And I'm going to be very busy. I assume many of you are as well. But I will still try and put out the long form content because I know some of you guys really like that too. So we're going to try and do all of it all the time. You can always come and watch on Twitch as well. There's plenty of Twitch content because that is just wind down type stuff, but it's open for your questions. Just come hang out on Twitch. You can ask questions and stuff like that, and I will answer them there as well. Or just come and banter and have a good time. It's a completely different format, and so I'll still be putting out a bunch of content. It's just there might not always be a YouTube live stream because we're not just going to do YouTube live streams for the purpose of doing one. We'll do one so long as there's something to talk about that's relevant. But anyway, and there is a lot of stuff to talk about. I also have to have enough prep to do it, but that's all beside the point. So, final thing. Definitely go be a coomer and a cumbrain. Whatever those terms mean, and whatever glow in the dark created them, definitely be those things. Because it's such a weird new lexicon that sprung up overnight. So do it. We've got Welsh D. Drigg says, having some Glenfiddich 18 year for my 24th birthday. Here to have a drink with me. Looking forward to a productive stream ripping Wick Phillips apart. Well, I don't know how much ripping we did. A little bit of laughing. And let me clarify something about the purpose of this stream. Wick Phillips served their client. I don't know what Wick Phillips' personal opinion about the whole thing was, but their client asked them to sue for these things, and they did it. And lawyers who pretend that you don't do what your clients ask you to do, those aren't lawyers with clients. Frankly, they're just not. So it was real cute for these people to come in and decide that that Vic's case is dead in the water and stuff like that. But Wick Phillips's case in this instance was dead in the water to a much greater degree than Vic. What damages could they even show from any of it? From any of it? What? They couldn't show $1's worth of damage from an online review. Not $1. They can't show $1's worth of damage from the tortious interference with prospective business relations. They can't show any of it. They can't show a single $1's worth of damage to any of that. They had to know those statements were not defamatory. Any lawyer on earth could tell you they weren't defamatory. Vic's case has 400 statements. And remember that a lot of the sped lawyers out there who are really opposed to it, they focused in on those couple statements from the TDMA letter. And yes, haha, they're very funny. But you know what's even funnier? The really smart attorneys for Rial and Toye never opposed the propriety of the TDMA letters. Not once. And they could have. They could have attacked them for being not timely. They could have attacked them for being not sufficient. They could have attacked them for all sorts of grounds, and they never did. They never did that. And so therefore, no matter what you think of what's in those TDMA letters, they're valid for the purpose of this lawsuit. There is no objection to them that was raised. Never. Ever. Oh, wait, that's not true. It's not true. They improperly sort of objected to them by taking a special exception to them in their answer. But a TDMA letter requires a specific motion opposing it. And they didn't do that. So the TDMA letter was presumptively valid. That's the funny thing here. As much as they may want to rip on Ty's firm for that letter was effective as far as the court is concerned, and contains all of the statements that Toye makes because it references them in the letter. They should have objected to that. They should have filed a motion that that wasn't sufficient. And then they could have sent a letter with particularity for each of the 400 statements. Or they could have pared it down. But they didn't do that. So Law Twitter got their jollies off by drive-buying on this one particular letter. But that letter actually is effective in the suit. The rest of what happened, we'll have to see what the appeals court says. But for any of them suggesting that the defamatory statements made about Vic do not rise to the level of a lawsuit, if they think that these did, they're being disingenuous. And if they think that a lawyer bringing this suit is so stupid, well, then it must necessarily follow that Wick Phillips is at least as stupid, if not more so. But that's not true. Right? None of these people are stupid. I mean, Lemoyne is stupid, but that's for different reasons. None of the people involved are stupid as far as lawyers go. They make ridiculous arguments sometimes. They may oversell their hands sometimes, but that's what lawyers do. And there's a disingenuous air of Law Twitter or an ignorance, and that second one is a lot scarier than the first. So I just wanted to point that out. So anyway, Supreme Gentleman Founder ADL said, would you rather donate $100 to the ADL or have to wear Vic's pants for a month straight? $100 to the ADL. Maybe $200 if I had to. The Claude Gamer says, normally I wouldn't recommend people see my channel, but the 15-cent GoFundMe video is up and would really mean a lot if you guys saw it due to the time and money it took. So there you go. Go check out the Claude Gamer, guys. Cerulean Voice says, give this to Siren Jag for making me laugh for a full minute, R.E. Sacred Ointment. No, I won't, but he can vicariously enjoy the $5. Spicot84 says, as Christian, I rebuke and potty him. That's the to the emailer. Lil Poo Poo says, I want to be in the next email. This guy talking big to compensate for a tiny PP and wears a crappy tinfoil hat, lol. Talbot Link says, long time no see. Hey, what's up, buddy? Expect a late Christmas package. Been busy with life and cleaning on and offline communities for infiltration elements. Cheers. Some nobody says this is way sillier than before. 3 and sadder. GR People says, ask your email buddy about how everyone in Hollywood is a man in a dress. Mandar told me so. Some nobody says, there goes your monetization forever, I guess. I don't think so. Maybe. Cathurga says, God didn't want there to be a king, but Jesus is an exception, I guess. P.S. This guy really does remind me of OG Illuminati conspiracy channels. Hey, don't besmirch those channels. Bad Dragonite says, how hype are you for the new all-female fight club? Oh, is that a thing? That sounds great. True to the book, even. Cynic in Chief says, why did Wick Phillips want to grind Alan into dust? I have no idea. Some nobody says, 3. Hit that thumbs up, bitch lords. The Nerdiest Geek says, December sounds like a great month to do more Ace Attorney than why do you do this to me? Why do you hate me so? Maybe. We'll see. Cloudfire181 says, hey, Nick, been a while since my last super chat. I sent you a follow-up email recently needing details from you. Okay. Sounds good. Thanks a bunch. I'll find the email. All right, guys. That's... Oh, wait. Keylancer 13 says, the author of those letters appears to be channeling the spirit of the late Francis E. Deck Esquire, fighting the good fight against the communist gangster computer god. Oh. And Jay says, hey, Nick, I was doing a little content analysis of Lemoyne's filings. TCPA sanctions motion for leave. He has written just over 8,000 out of 18,700 words on you and the GoFundMe in those 3 motions. Well, I'll have to see if I can get even higher next time. And then finally, GR People says more Ace Attorney. Maybe. Not tonight, but maybe. Maybe soon. All right, guys, let's get this outro playing. Oh, no. Oh, no. I had it in the wrong audio. There we go. There's the outro playing. I now have the outro saved in my Coomer Stream Deck. So now I can play it for you guys. To you all, thank you for joining me. Come join me on Twitch. Should be a fun time. Keck and I are going to play Dawn of War 2 Retribution Co-op. The co-op campaign. So come follow on Twitch. Join us. Have a good time. And I will see you very soon. We've got more crazy emails, but I'm not going to do them all tonight. Thanks, guys. Have a good night. I'll see you around. Peace. Peace.
Make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the most who'd get unemployed. So pour out a glass for the tea post on Twitter as we hear Lawsplaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now.